Good morning. It's my pleasure to welcome you to our breakfast seminar on the new DOL salary requirements for exempt employees. And I'm just going to do a few introductions and then we're going to jump right in. My name is Mary Crocco. I'm one of the members of the Employment and Labor Group here at Fredrikson and Byron. And in your packet, you should have found 2 documents from the Department of Labor that we reprinted for you because we think they are helpful and you could find them useful. It's the one with the little blue on it, the Small Entity Compliance Guide. And even if you are not a small entity, I think you'll find this useful. And then you also, I think, have, right, the overtime for white-collar workers, that summary, just a short little 3-page document. Okay, and then you have our PowerPoint document. We're going to speak from that so you can take notes as you wish on that. All right, and together with me this morning, I have to my immediate right, Ingrid Culp, and in just a minute after I sit down, Ingrid is going to get started. And the reason I'm standing is because I have to speak directly into this microphone for the tape recording to work, so that's why I'm doing that. But then we're just going to sit. Okay, and Ingrid's going to do the background on wage and hours, so we all get on the same page. Then I'm going to jump back in and I'm going to do the new rules and regulations. And then immediately to Ingrid's right is Ann Radolinski and then Krista Hatcher. And they're going to cover next steps and options for compliance. And then on the far right is Ashley Tronson, and she's going to tell us about wage and hour litigation and some of the legal risks there. All right. So you should have on your tables, I see them there, the yellow cards where you can write questions. Please do that as we go. Write any question that you want and pass those to the left or to the right. Kate and or Kelly, 2 of our very important marketing people who help us all the time get these seminars together, will come around and pick those up. And we will do our very best to save time at the end to answer your questions. So I think that's it for now. Ingrid, your turn.
Okay, how's that? All right, sounds good. Well, I have the really easy job today, which is just laying the groundwork of what law we're even talking about today and what has been the law for the last many, many years and what is still the law today and will be for just a few more months before the new rules that the DOL and Congress have put into place come into effect. So let's get grounded in what our topic is today. So the law at issue is the Fair Labor Standards Act. The Fair Labor Standards Act is a federal law that applies to almost all employers in the United States, and we'll talk about that in a little bit more detail in a minute here. There are also many states that have adopted their own version of the Federal Fair Labor Standards Act. And so we also always have to think about state law and how the state law and the federal law interplay with one another. Whenever you have a federal law and a state law that both afford employees various protections, the general rule is that you comply with the law that is most beneficial to the employee. So for example, here in Minnesota employers are subject to the Federal Fair Labor Standards Act and the Minnesota Fair Labor Standards Act. In many, many respects, the laws essentially mirror each other, but there are certain instances where they don't mirror each other, and Minnesota law is more generous than the federal law. So it gives employers quite a puzzle to figure out both federal law and state law, and then again, whenever there's a conflict, follow the law that is most beneficial to the employee. Our focus today is going to be the Federal Fair Labor Standards Act. So who is a covered employer? A covered employer under the Fair Labor Standards Act is any company or entity in the United States that has annual revenue of at least $500,000 a year. So a fairly low threshold for most businesses. If your company has revenue of at least $500,000 or more, you are a covered employer. Or, regardless of revenue, if you're a hospital, medical, or nursing care facility for residents, a school, a preschool, or a government agency, you are just automatically covered by the Fair Labor Standards Act. Even if you are not a covered employer, which most of us are in the United States, you may well be subject to the Fair Labor Standards Act because your employees are covered employees. So you are either a covered employer or your employees are covered employees, or in most cases, you've got both. You're a covered employer and you've got covered employees. So what does it mean to be a covered employee? A covered employee who is entitled to the rights and benefits of the Fair Labor Standards Act is any employee who works in interstate commerce. So what does interstate commerce mean? This was a term we learned a lot about in law school, and essentially what it means is any interaction with any goods, services, or communication that cross state lines. So, as an example, if you have an employee who works with goods or services that either come from across state lines or are shipped later across state lines, or they place or receive telephone calls from across state lines, or emails from across state lines, or faxes from across state lines, or, as Mary will tell you, she once sat in a DOL audit, and the DOL auditor looked around the conference room and saw some hand soap sitting on the counter. And the auditor said, yep, interstate commerce, that hand soap was manufactured somewhere else and shipped here. So
That's a true story.
So the takeaway with regard to what interstate commerce means is really almost every employee works in interstate commerce, given the day and age that we work in today. It's going to be a really rare employee who is not deemed to work in interstate commerce. So the primary takeaway about whether your entity or your employees are covered by the Fair Labor Standards Act is the answer is almost always yes. So what are the terms of art that we're going to be talking about today? Exempt and non-exempt. So let's give a little bit of definition to those terms. So non-exempt. A non-exempt employee is required by law to record their hours worked. The employer must pay them minimum wage for all hours worked, and the employer must pay them overtime at the rate of time and a half their regular hourly rate of pay for all hours worked over 40 in a work week. Non-exempt employees can be paid hourly, salaried, or really any other means of compensation, but most employers pay their non-exempt employees hourly for reasons that we'll explain a little bit later in our discussion. Exempt. Exempt employees need not record their hours worked. They are not entitled to overtime pay under the Fair Labor Standards Act. But to be exempt, they must qualify for exempt status under at least one of the Fair Labor Standards Act exempt qualifications. So what do we mean by that? So the Fair Labor Standards Act has set forth exemptions. I think the easiest way to think about it when you look at your employee roster is the default position is all employees are non-exempt. All employees are entitled to overtime pay unless you can pluck them out of non-exempt status and put them into exempt status because they meet one of the tests that the Fair Labor Standards Act has set forth for exempt status. And there are several exemptions, and an employee need only meet one of the tests to qualify for exempt status. So what are the primary FLSA exemptions? We have the executive exemption, the administrative exemption, the professional exemption, the computer professional exemption, and the highly compensated exemption. There are also other exemptions not as readily applicable. For example, outside sales employees have an exemption, certain inside sales employees have an exemption, and there are certain other kind of fairly random exemptions. But these are the ones that we see applied most readily. So the executive exemption, what does it currently require as we sit today? This is the current law, not the new laws that Mary is going to talk about in a moment here. To qualify for the executive exemption, the employee must be paid a salary, a true salary, which is the same amount week in, week out, regardless of quantity or quality of work. and that annualized salary has to be at least $23,660 a year, or $455 a week. And this is an and, not an or, and the employee must have certain required job duties to qualify for exempt status. And if you pull out the printed materials that Mary referenced, the small entity compliance guide, and really do please disregard the reference to small entity. I'm not sure why the DOL entitled this document small entity. What you read in here applies to all employers across the board. If you go to page 6 of that document, you will see a detailed description of the job duties that are required for the executive exemption. And I'm not going to read those word for word here, but I just did want to call those to your attention. So if you want a refresher on what the required job duties are, you'll see them there on page 6 of this document. Now, I have so often heard clients and employers say to me, oh, you know what, these employees are exempt because they're paid a salary. And I say, well, that's one of the two-part test. And so I really do want to emphasize the two-part test is connected by an and, not an or. Both the base salary and the required job duties must be met. The administrative exemption, again, you'll see that there must be an annualized salary of at least $23,660 a year, and the required job duties. And again, those required job duties are set forth on page 7 of the document that I just referenced. On the administrative exemption, I really will caution employers that the Department of Labor takes a really narrow view of who qualifies for the required job duties for the administrative exemption. It is really, in the DOL's eyes, reserved for your high-level administrators who have a lot of authority and discretion and independent judgment with regard to running the business. The third exemption, the professional exemption, again, an annualized salary of at least $23,660 a year, and the required job duties, which are set out on page 7 of the document I referenced. The professional exemption is really reserved for your employees who have a professional degree that has been obtained through a prolonged study in a recognized profession, like medicine, law, architecture, engineering, teaching, those types of degreed professions. The computer professional exemption. So the computer professional exemption, again, the job duties are in the reference document, is reserved for your high-level computer professionals who are really engaged in software engineering or other high-level, high-task, high-knowledge computer-type activities. This is not your help desk employees. To qualify for this exemption, the individual has to make an annualized salary of $23,660 a year, or this is one exemption where you actually can pay an hourly rate and still qualify for exempt status. The hourly rate for your computer professional employees has to be at minimum $27.63 an hour. Note that this is one of, if not the only exemption that allows an hourly rate of pay and have the employees still qualify for exempt status. And then again, the required job duties, which I would encourage you to review before relying on this exemption. And then finally, the highly compensated exemption. This exemption was put into place, I don't know, maybe 8 or 10 years or so ago, and remains in place today. To qualify for the highly compensated exemption, the employee has to have that annualized salary of at least $23,660 a year. But at the end of the day, their total compensation in the year has to equal at least $100,000. So $23,660 of their $100,000 has to be paid in a true salary, but then if they have bonus or commission or other forms of pay that get them up to $100,000 or more in the year, they will have met at least the compensation piece of the highly compensated exemption. With regard to job duties, under federal law, they only have to meet one job duty test under any of the exemptions I just mentioned. So you can look at the executive exemption, the administrative exemption, or the professional exemption. And if they are performing at least just one of the required job duties, they're going to qualify for the highly compensated exemption under the federal law. But note in Minnesota, this is one of these areas where federal law and Minnesota law differ. In Minnesota, to qualify for the highly compensated exemption, the employee has to meet all of the required job duties for exempt status, not just one of the required job duties. Okay, so that grounds us in where we are today and where we have been for the last many, many years. And I'm going to turn it over to Mary now to tell us where we are headed, effective as of December 1st, 2016.
Correct. Thank you, Ingrid. I don't think this one is still working.
No, it's not.
Give that one back. Now I'm working. I don't know what's wrong with that microphone, but we can trade. Good. Thank you so much, Ingrid. That was a great background. And so let's jump into what's new. I'm sure you've been reading about it already on the internet, et cetera, but let's go through it kind of point by point. The final regs that will take effect December 1st, 2016 tell us there is no change in the job duties tests. And that's good, because it makes it a little bit easier, right? That was open to question because in the draft regulations, they didn't propose changes, but they talked about maybe they would, all right? But they did not. So the job duties tests remain the same. It's the big change in the required salary that we have to be ready to implement no later than December 1st, 2016. And what is the new required salary? Well, I've given you the various amounts depending on how you pay, but the annual salary for a salaried exempt employee effective December 1 has to be no less than $47,476. Weekly, $913. And I think that's an easier number to always keep in my head, $913. If you pay bi-weekly, then it's $1,826. But bi-weekly means you give 26 payments a year. Can you multiply that out in your head real fast, times 26? It does not quite reach $47,476. But that's the number in the regulations. So that's the number I'm going with. I did the math, and it doesn't quite come out exact. Somebody else do it, and you tell me if I just was wrong using my calculator. If you pay semi-monthly, which means there's 24 payments a year, then the amount is $1,978. And if you pay a monthly salary, that's $3,956. Okay, so those are the amounts. But the one I try to keep in my head is $913 and then $47,476 a year. Now, they have a few special rules. American Samoa, anybody in here have employees in American Samoa? No. Okay. Well, if you ever do, there's a special amount, $750 or $767 per week. I know there's at least one person here because I met you in the elevator this morning. That was very nice. Motion picture producing industry. You have a special salary that applies to you, $1,397 per week. All right. And the computer professional employees will still have the hourly basis for payment available to them. So you either do the salary or you can do the $27.63 per hour. Also, don't forget there are special rules if you're in a school. The administrative employees of an educational establishment have special rules. Anybody here with that? No. But if you ever do, look up the rule. And then teachers, physicians, and attorneys are not covered by the salary basis requirements, the salary requirements. So they can be paid hourly, they might be paid very, very little, they might be paid lots, but there are no wage and hour regulations that apply to them. So some special rules, and those have always been the case, they just kept those in the regulations. All right, so you have to do the $913 a week, all right, week in, week out for a salaried exempt employee, but up to 10% of the weekly pay can be non-discretionary bonuses, incentives, or commissions. That would mean you could pay $822 per week if for the quarter, and you pay it no later than the first pay period after the end of a quarter, and they're taking calendar quarters. So after March, April, May, after June, after September, and then after December, if you make up the difference so that they get no less than $913 a week equivalent, that would be okay. So 10% of that salary can be non-discretionary bonuses. And of course, that means we have set how you earn the bonus, right? Here are the criteria. You meet these criteria, you receive the bonus, incentives or commissions. All right. Also, when the salaried exempt rule applies, the person must be paid $913 a week, or that $822 if you're going to use other payments for 10%. But a question that comes up quite frequently is, can I pay my salaried exempt employee more? Right? Because maybe they're going to do a special project for the company, or maybe they're really going to have to work 80, 90 hours this week because we are in a crunch. And the employer thinks, can I pay the salaried exempt person more without risking the person's exempt status? And federal rules say, yes, you may do that. And you may do it in any way you choose, including commission on sales, percentage of sales or profits, or just extra pay for extra hours worked, including an hourly amount, a flat sum, or even time and a half. Now, here's the little trick of that, and it goes back to what Ingrid said about Minnesota and federal. We always have to meet both. Minnesota has never blessed that kind of payment for salaried exempt employees. And in fact, if you've been in the business a while, I have, most of us have for a while, we remember the day when the rules were such that paying a salaried exempt person more than their salary, especially if we paid it in an hourly or time and a half method, was regarded as making that salaried exempt person look like they were non-exempt, right? I see a few heads nodding there. You've been doing this long enough. You remember that day. Well, that's the risk under Minnesota law still. But there is nothing in the Minnesota regulations, administrative rules, that tell us we cannot pay extra. Like the federal, they specifically now say we can, but nothing in Minnesota says we cannot. And I have never seen, anybody here ever seen, the Minnesota Department of Labor and Industry object. So I've never seen it happen that there was a problem with that, but I would just caution you on that because, of course, we don't have that rule in Minnesota. And some of those people have been around a long time, too. They might remember the old stuff rather than the new that tells us, yeah, we can pay more for the salaried exempt person, and that's just fine. All right. Now, you might wonder, because I certainly did, where does the Department of Labor come up with these odd numbers? Why $47,476? Why $913? Just make it $950 or $900, and then we can remember this better. No. They had a methodology, all right? And it comes from the 40th percentile of weekly earnings of full-time, non-hourly workers, so that would be people who are paid a salary now, in the lowest wage census region of the U.S. And right now, that's the South. So that's where they got the number. So they use some methodology to do that, just in case you were wondering. Also, remember how the $23,660 that Ingrid talked about, $455 a week, right now seems really low, doesn't it, to you? I mean, it does to me. $455 a week, $23,660 a year. That's a low-paid, salaried exempt person. But that's been in effect for quite a number of years already. Why did that happen? Well, because they didn't build in any kind of automatic increase. Well, the Department of Labor has looked ahead this time, and they've planned better. The new rules say that beginning January 1, 2020, that's 2020, and every 3 years thereafter, the Secretary of Labor automatically will update the salary requirements, so be on watch, and they're supposed to publish it in the Federal Register by 150 days before January 1st. I counted that back. I got to August 3rd. My fudge it one day or the other, but early August, of the year before the salary will go up, they're going to publish the amount. So watch for that. The new rules also keep the fee acceptable alternative for administrative, professional, and computer. And of course, if you're paying a fee, you do it by what's the fee paid, divide by the number of hours worked, which means this salaried exempt person, not salaried, but exempt person is going to have to track hours, and then divide the fee paid by the hours worked and see if they get to the minimum weekly salary, $913, if they had worked 40 hours. All right. And there's a couple examples in the material. So, for example, if you pay $500 for a professional to do a drawing and they work 20 hours at $500 per the drawing. If they'd worked 40 hours, then theoretically you would have paid them $1,000. That's enough. All right. And you can see the example. But if you ever have a question on that, my strong encouragement is to consult with legal counsel to make sure the fee that's being paid is sufficient. All right. The salary basis rules still apply, and Ingrid went through a little bit of those. And let's just remind ourselves what those are so that we don't forget. No deduction for quality or quantity of work, full weekly salary regardless of hours worked. So the person had to leave early for a family emergency or for illness. And if they had PTO or sick time or vacation accrued and available for use, and you require them to use it, you can deduct against that pot of money, but they still get their full weekly salary, remember? And if they've used up all of their paid time, accrued paid time, then you still have to pay the full day's wage if they worked any part of a day. But if they miss a whole day, right? Everybody tracking with me? Does that make sense? If they miss a whole day, then you don't have to pay them for the missed whole day. But if they work 3 hours and they had to miss 5 and they don't have any PTO, they get paid for the whole day. But of course, no salary for a week if they perform no work, which I think is really hard to do when you're a salaried exempt employee, given your duties. And what do we have in our back pockets that sit on our nightstands these days even? That wonderful little it's not even a cell phone, a smartphone, you know. It's hard for a salaried exempt person not to do anything unless they go to some location where they don't have cell service, potentially. Okay, and no deduction for employer-caused absences. All right. Onward, be sure you include in your employee handbook or your personnel manual what we call the safe harbor language in case you inadvertently make a deduction against a salaried exempt employee's salary so that you can correct it without liability. All right? If you have questions about that, let one of us know and we can help you with that language. All right. Now, remember the new required salary, $913 a week. That's the number I'm keeping in my head. That applies whether your salaried exempt person works full-time or part-time. And I've already had this question several times already from my clients because it's a big deal. For example, professional exempt physical therapist works 2 days per week for 16 hours, right? 8 hours, 8 hours. Currently paid a weekly salary of $800, which if you divide that out, pretty simple math here, it's $50 an hour, right? Well, under the new rules, you either have to pay that person $913 a week to get up to the minimum salary, even though they're only working part-time, $913 a week, which I think comes out, I did the math, to $57 an hour, which, you know, just as a guide, might not be out of range, out of doability for the company. Or you can convert that person to what we call salaried non-exempt. And Krista and Ann will talk more about this. But there you have to track the hours. And if they would happen to pay overtime then you have to pay overtime after 40 hours. Well, if they're only working 2 days a week now, the likelihood that they're ever going to have overtime seems slim, very slim. All right. But remember, too, as when we talk about tracking hours worked, my benefits lawyer here at the firm reminded me, Mary, be sure you tell those people that tracking hours for Fair Labor Standards Act is not the same as tracking hours for benefit purposes, okay? Just put that in your back pocket and remember that, okay? I told her I would be sure to say that. Okay, what's happened with the highly compensated employee? Well, as Ingrid said, other than Minnesota, it's still the same rule, but now it's $134,000 $4. Again, that's one of those odd numbers. I'm like, and why did they tack on the $4? Just round it, would you? And then somebody said, oh, yeah, well, Mary, it was $134. $134,004.80. They did round it. So there. Oh, yeah, sure. Okay, and they have to have at least one exempt duty. So they're a white-collar kind of office, non-manual work employee. You'll make it for federal. But again, here in Minnesota, consider carefully whether you may use it. You still have to pay the $134,004 a year, but you have to meet all required duties for the type of exempt employee that you want to apply it to, all right? All the duties. And Minnesota is like the old federal, all of the duties tests. Okay, couple of quick things. The DOL has said that it will not enforce the new required salary until March 17, 2019. So a long time from now. If you are a provider of Medicaid-funded services for individuals with intellectual or developmental disabilities in residential homes and facilities with 15 or fewer beds. Anybody think that applies to them? Okay, nobody here today. So if you know anybody like that, though, be sure to tell them that only means you don't have to pay the new salary of $9.13 an hour. You still have to, the DOL will enforce all the other exempt requirements, the job duties, $4.55 per week, et cetera. All right, that's one new exception. And then we're getting a lot of questions about this. Nonprofits. If you are a nonprofit, the DOL went into a great deal of detail about how the new salary will apply to a nonprofit because, of course, $9.13 is a big jump from $4.55 if you're a nonprofit, and budgets are tight generally. All right, so they say a nonprofit, just like any other enterprise, is not covered if you don't have sales or business done, all right? So if the only thing your nonprofit does is charitable services, such as temporary shelters, clothing and food to the homeless, counseling, etc., then you're not covered, all right? Because you don't do any business like the enterprise, $500,000, right? Now, you are, though, covered, just like always, if you're a hospital. Even if you're a nonprofit hospital, you're still covered. Or you care for older adults and people with disabilities who reside on the premises. That would be long-term care facilities and schools with children, for children with disabilities. They're always covered. And if you're a nonprofit and you do some business, so you have sales made or business done of $500,000 or more annually, then you are covered by the new rule. So think of if a nonprofit has a gift shop, if they sell donated clothing, they operate a restaurant, etc. I think of ARC. Do you know ARC? There's one not too far from me. I would have to believe they do $500,000 or more of business per year, even though they take donated items. I drive up and dump my stuff. They take it, but they sell it, and I'm sure they make $500,000 or more per year. So they are going to have to meet the new salary requirements, all right? And just one more thing here that is getting a lot of play. Remember, like Ingrid said, companies are covered by the Fair Labor Standards Act either as a company as a whole, the enterprise, because there's $500,000 or more of goods or services sold during the year. And even if you don't meet the $500,000, individual employees can be covered by the Federal Fair Labor Standards Act because they work on, help produce, touch goods or service that travel in interstate commerce. And Ingrid gave you examples, and they're kind of the ones that I have here. Phone calls across state lines, mail, email across state lines, ordering goods from out of state. That was the example of my DOL auditor who walks into the conference room, sees the bottle of soap sitting there. Also, it was a box of Kleenex she pointed to the two and said, okay, you're in interstate commerce. I'm just sitting there going, okay, well, we didn't say we weren't, but okay. I just found that so remarkable that she'd point to those two and verbally say, that makes you in interstate commerce. Okay, good, fine, whatever. Handling credit card transactions or doing accounting, bookkeeping for such activities, and there could be others. So my real hefty caution to nonprofits who somehow think, well, we don't do $500,000 worth of business, so we're not covered. We're not a hospital. We're not a long-term care facility, so we're not covered. And then they say, and our employees, they don't touch interstate commerce. I would take a very, very critical look at that before coming to the conclusion then that we're not covered by federal law. So if you're a nonprofit, that's my caution to you. Okay, so those are the new rules, and I'm going to turn it over to Ann, I think, and Krista, and they're going to talk about next steps and options. We're going to move that laptop.
Oh, okay. Does this one work? Yes? Good. All right. So good morning, everyone. Where do these new regulations leave us? Do they leave us with chaos and mayhem? Those things do come to mind. These regulations are deceptively simple, but they have enormous financial and administrative impact, which I'm sure all of you are feeling. In reality, the new regulations only affect a very limited portion of the overall wage and hour requirements. As Ingrid and Mary have described, the various tests for exempt, non-exempt status do not change. That has major implications, as I will talk about in a moment, and from a practical perspective. The record-keeping requirements did not change. The various methods for calculating overtime, which many of you know can be very complex, have not changed. Only the salary and fee thresholds have changed, and what goes into meeting those thresholds have changed. Employers, in essence, have to pay quite a bit more if they are going to have an employee be in that status where no matter how many hours they work in a week, they're going to be paid a certain amount, a guaranteed salary. The reality is, though, that we have had months and months of media buzz, and the DOL has contributed to that substantially. For those of you who haven't been, had your hand to the pulse on that, it's been a buzz on social media. It's been a huge a point of discussion publicly with the DOL in the months and months leading up. The administration has been touting these new regulations. What does this mean? Of course it means that employees are going to be thinking more and more about their compensation and their compensation rights. The employees are likely to not understand that these new regulations don't really change everything. They change some things. We can expect that both the employees and their wage and hour council, which Ashley will emphasize to us in a few minutes, are going to be looking for cases, complaints, ways in which to take advantage of the new regulations. So what is our advice in light of this? What are we expecting to see? We are expecting to see an uptick in internal and external complaints. As I mentioned, employees may not understand the intricacies of what has changed and what has not. Compensation is near and dear to every worker's heart. You can't blame people for that. That's the reality. They may see some people's compensation going up. They may, in their particular situation, a company may decide that the company doesn't want to bump up their salary to the $47,000 level to meet the exempt status, that they're going to be set at an hourly wage, and that hourly wage may not directly align with what the salary they were making was. So you're going to see a lot more, I think, internal and also external complaints. Employees that are disgruntled, that don't understand what's going on, go to the DOL, and the DOL becomes interested. As a practical matter, and this is very, very, very real, this is the DOL's baby, this compensation piece. And they are waiting for audits. I don't think anybody would disagree with that. They may not come right away, but I think we're going to get them. And how many of you have had the pleasure of having a DOL audit? Anybody? Oh, good. Only a few in this room. I will tell you. So the DOL comes in, and they're not allowed to tell you why they're there. But oftentimes they're there because somebody picked up the phone and called them and told them about something. You know, that they feel that they're classified as exempt and they shouldn't be, that the timekeeping practices aren't what they should be, any number of things. But when the DOL comes in, it doesn't just investigate that little complaint. It does a full-fledged audit of your pay practices, your timekeeping practices, and everything under the sun. And I think we can expect more of these. We're going to talk about ways in which you can minimize this risk, but I just want that to be out there. And the state DOL, you know, we still see state DOL audits, particularly since in some ways the Minnesota wage and hour laws are more generous than the federal wage and hour laws. So we always have that risk. But for purposes of these regulations, I think we're going to see more of an uptick in the federal DOL audits. So what are the recommended next steps for us? You can just imagine, and I would imagine that many of you are already engaging in them, in light of this risk. So what we are recommending to our clients is to use this as an opportunity. This doesn't go into effect for a few months here. Use this as an opportunity, not just to evaluate your compensation levels and whether your exempt folks are meeting that $47,000 and odd dollar level and the $913 a week level of pay, but examine all of your practices because, as I said, if you get an audit, it isn't just that the DOL is going to be looking at. Evaluate your options under the new regulations in terms of the salary levels and your exempt, non-exempt status to determine from a business and financial perspective and also a compliance perspective what you want to do with folks that are classified as exempt that maybe shouldn't be, folks that are classified as exempt that should be under the duties test or can be, but for whom you don't want to raise their salary substantially. Develop an action plan and make recommendations to upper management. You have to get the buy-in. A lot of my clients are already doing this. I've been in wage and hour audit mode, internal audit mode with clients now for a couple of weeks. Make recommendations to upper management and then carefully plan the rollout. And Krista and I will talk about this in terms of communication to your employee base, both to the affected employees, but you may want to consider your communication to the employees at large, depending on what numbers in your workforce are affected by this. So when I say audit, internal audit, what do I mean? I mean a full audit. Look at certainly what positions you have currently that are classified as exempt, what positions you have classified as non-exempt, and ensure that your exempt positions really meet those duties tests. Those criteria that Ingrid was pointing out to us in the handout for administrative exempt, executive exempt, professional exempt, computer exempt, and then we have all sorts of other exemptions, are deceptively simple. Those words, though, carry a lot of meaning in the regs. So what constitutes, for instance, independent discretion and judgment to a normal person, you and I, well, I'm no longer a normal person, I'm a lawyer, so I can't think normally, but is not what the DOL thinks, and it's not what the regulations specify, and it's not what the case law specifies. So you may have a person in an exempt position right now who is the position is incredibly important to the organization. They perform an incredibly important role, but they may not be legitimately in an exempt position. The other thing to remember is that your job descriptions may be perfect, for your exempt employees. I just went through this with several of my clients in the last few weeks. The job descriptions were great. I look at the job descriptions and I've got the criteria in my head and I'm thinking, yeah, we've got real good arguments that this position comes within administrative exempt or executive exempt, et cetera. But then as I ask, which is the key question, because this is what an investigator would ask, what does this person do on a day-to-day basis? What they're actually doing and what the job description describes is very different. So you could have a person in an exempt job by their job description, and the DOL would find them to be non-exempt. So anyway, that's a big piece of this audit. Current compensation levels, definitely. Look at your record-keeping practices, because if the DOL comes in on any kind of a complaint, they're going to be looking at your timekeeping practices. Are people being paid fairly according to your timekeeping system, or at the end of the day, does it look like they are putting in time that is off the clock? Are they punching in at 7:45 and actually starting work at 7:45? Are they punching out at 4:15 and they're still doing work during that time? And you're only paying them 8 to 4. That's an obvious example, but there are many others. Are breaks being appropriately provided? Are lunch periods, both paid and unpaid, being appropriately handled? Is your overtime being calculated appropriately? Are there authorized, unauthorized, or unlawful deductions being made from exempt salaries pay, non-exempt salaries pay also? And also review your handbook policies. I find this a lot. This was before the new regs, but my clients' record-keeping policies and their other practices are in conformance with wage and hour laws, but their policies speak a different story, and this is something that the auditors look at when they come in. When you're doing these internal audits, consider very carefully, and I'm not saying this to drum up business for us, honestly, I mean this sincerely. Consider carefully whether you want to do this under attorney-client privilege. You can actually accomplish this without having one of us come out and do the full audit for you. But the reason why you want to do this, there are many reasons why you want to do this, in the course of creating or going through an internal audit, you may end up creating records that you really wouldn't want the DOL to see or a plaintiff's attorney to see if you got into a wage and hour collective action. If you involve your attorney, they will come up with strategies for you on a cost-effective basis for keeping the pieces of this under attorney-client privilege that you really want to be under attorney-client privilege. The other reason is this, and this is just the practical reality. You may conduct an internal audit as an HR professional, compensation professional, et cetera, or even, if you're the CFO. But the powers that be may not buy into the changes you're recommending. So if you've got a document out there that says that the following positions have been misclassified and need to move from exempt to non-exempt status, and those changes aren't made, you can imagine what that would be in the hands of the DOL if they saw that, or a plaintiff's attorney in the course of litigation. The timing of an internal audit, I think, is perfect right now from a communications perspective. My clients are telling me that they are getting more buy-in from upper-level management for doing an internal audit, because upper-level management is seeing and hearing and reading about all the buzz and the risks. So that's fantastic. It's also, though, very opportune in terms of communications with employees, because you can do a full-fledged audit, clean up the things that you've been wanting as a HR professional to clean up for quite some time, and you can do this under the guise, when you communicate it, roll it out to employees, that we have new regulations. So maybe, these employees will not think about, well, you're changing it going forward, well, what about the last 2 years? So you have an opportunity, I think, too, from a risk management perspective, to do a bit more here. Additional factors to consider. I have to use this. I never get the hang of these things. It's you now. I'm jumping ahead too far ahead. Oh, you can do it here?
Yeah,
okay. There you go.
Yeah. So once you've conducted this audit, the next step is, of course, to take action on that audit. And Ashley will talk in a few minutes about litigation risks, but a few of the areas where we see a lot of wage and hour litigation, a lot of investigation by the Department of Labor, are these areas that surround payroll practices, that surround practices that affect non-exempt employees. So in a few minutes, we'll get into the meat of what these regulations will have an impact on exempt employees, but I want to talk for a few minutes first on these sort of surrounding issues. So Anne mentioned timekeeping. So timekeeping is a pretty significant area of litigation. If you've got non-exempt employees, and we're talking here about employees currently classified as non-exempt, and if you're going to have employees that are currently classified as exempt but might be non-exempt come December 1, look at timekeeping practices. So you might have folks who put on uniforms before work and take them off at the end of the day, who put on special safety gear, who have to travel from one part of the work site to another. In some situations, those must be paid and they have to be counted towards hours worked for overtime purposes, and other situations not. So that's an area to look at carefully. And then if you have more non-exempt employees now, because you're going to be classifying employees from exempt to non-exempt, just make sure that you have the mechanisms in place to track their hours worked. Also, breaks. The Fair Labor Standards Act does not actually require employers to provide employee breaks, but many state laws do, including Minnesota. What the Fair Labor Standards Act does say is that certain breaks must be paid and have to be counted towards hours worked, again, for purposes of determining if an employee is eligible for overtime. So those short breaks, 5 to 20 minutes, those have to be paid and counted towards hours worked for overtime purposes. Longer breaks, bona fide meal periods, those don't need to be paid, and you don't have to count that time towards that 40-hour-a-week threshold for overtime under federal law. But the question is always, are your employees getting a bona fide meal break, or are you requiring them to work through that? So that's another area to look at, and if corrections need to be made, it's a good time to do it. Again, off-site work, we mentioned how many of us keep our phones on our nightstands and check emails one last time before bed. Totally fine if you're exempt. Non-exempt employees, if they're doing that routinely, if the employer's expecting them to do that, again, that's time that might need to be counted towards hours worked. And then the big one, where these regulations affect the salary, they don't affect the job duties, but in the course of this audit, you might discover that, oops, we have employees that we've been paying a salary and we've been treating as exempt, but I don't think they actually meet the duties test now that I look at it more closely. So through this audit, you might discover that there are employees who meet the salary basis test. They might still meet the salary test in December, but their duties aren't exempt duties. December 1st, when these regulations go into effect, is a nice time to implement these changes between now and then, because hopefully with all this going on, it raises a little bit of less of a red flag with the other changes. So let's talk about those folks who are classified as exempt and who will be affected by this increase in the salary. There's a couple of things employers can do now with the increased salary. One is to reclassify these folks as non-exempt. If their salary is pretty significantly below that $47,000+ threshold, and we don't think we can get to that point, even including in those non-discretionary bonuses and commissions, they can be classified as non-exempt. And like I said a moment ago, reclassification might be required if, in fact, it turns out that they don't meet that duties test as well. I think there's a pretty common misconception among some folks that non-exempt employees are paid on an hourly basis, because that is the typical way that non-exempt employees are paid. And certainly you can start paying these folks on an hourly basis. You can switch them from salary to hourly. You can, for example, take a look at how much they're making right now, divide that by how many hours they typically work each week, and then just start paying them on an hourly basis. And part of the communication can be that it's really not a change in their overall pay. On the other hand, you can continue to pay them on a salary basis. That has a little more cachet for employees, I think, particularly those folks who've been treated as exempt and paid on a salary basis for their entire career with your company. It's just a little bit more administratively complicated. There are actually different methods by which you can pay employees on a salary basis and still pay them overtime, because that's the key. Non-exempt employees, you can pay them on a salary basis. They still must receive overtime if they work more than 40 hours a week. So like I said, there's different methods of doing that. You can pay them a fixed salary for a expected number of hours worked. If you've got somebody who typically always works 40 hours a week, they get a salary for that 40 hours. Then if by chance 1 week they work 50 hours, they will get time and a half. So you take that fixed salary, divide it by 40, that's their equivalent hourly rate, and give them time and a half of that for the extra 10 hours of overtime on top of their salary. There's also a method called the fluctuating work week that allows employers to pay non-exempt salaried employees only half time for overtime hours worked. That's really appealing to employers because, of course, you're paying significantly less overtime. There are several requirements that have to be met to pay the fluctuating work week. So the employee's hours have to actually fluctuate from week to week. They have to be paid a fixed salary. That salary has to be at least minimum wage, even when they're working those high-hour weeks. So you can't pay them such a low salary that if they work a 60-hour week, when you divide that salary by 60 hours, they don't meet minimum wage. And there has to be clear understanding between the employer and the employee that this is the understanding, this is the payment system. So if that's something you're looking at, I recommend talking with legal counsel about it, but it's a good way to save on overtime costs. Another way to manage costs is managing hours worked. Again, so we have employees that were previously treated as exempt. We didn't care really how much hours they worked, if they worked a few extra hours a day, a week, because we didn't have to pay them overtime. If we're now reclassifying them as exempt because we can't hit that $47,000+ a year threshold, it might be time to start looking at their hours and managing hours worked. So setting expectations, instructing employees that unauthorized overtime isn't allowed. Now remember, non-exempt employees, if they work unauthorized overtime, they still have to be paid for it, but they can be disciplined for working that unauthorized overtime. And then again, because non-exempt employees, you have to track their hours worked, these are folks where they'll have to start tracking their hours worked. The Department of Labor says employees don't have to literally clock in and clock out. They don't have to punch in or punch out on a timekeeping system. There just has to be some complete and accurate method of tracking daily hours worked. So it might depend on what you currently use for non-exempt employees, how you will track these newly non-exempt employees' hours worked. Alternatively, we can continue exempt status for these folks. And that might simply mean taking a look at their salaries, doing that financial analysis and saying, look, they're really close to $47,000+ a year. We will increase their salary. One thing to think about very carefully is if you've got a group of folks who are kind of in that 40+ range especially, and who received bonuses, who received commissions, other incentives, look very carefully at whether they get enough in non-discretionary bonuses, enough in commissions, where if you count that 10%, that you can hit the salary threshold. Is there a way of counting those bonuses as a way of changing even their compensation structure where you can get them to that minimum $47,000+ a year without increasing the salary so much as instead of now just looking at the bonuses and commissions? Another thing to think about is, since we will have these automatic adjustments every 3 years, keep in mind a practice for future salary adjustments. What is your normal merit pay increase plan? Is it on an employee's anniversary date? Is it on January 1? Is it on the first day of your fiscal year? Think about how that will come into play, how that will interact with these automatic salary adjustments, if it makes sense to change the date of automatic merit increases. And then, of course, remember state law considerations. So, for example, do any employers have employees here in California? Yeah, so, yay, California.
Not.
So for a long time, as I think Ingrid mentioned, it's the law between federal law and state law. It's what's most generous applies. In California, they've long had a minimum salary that was higher than the federal. Now the federal is going to be higher than the California, but the California duties test is still stricter than the federal law. So throughout all of this, just keep in mind if you have employees in various states. Some factors to consider in deciding what course of action to take. And I think this is back to you.
I think so.
Okay.
Unless you want to do it.
Either way.
You know, as you're performing your internal audit of the, particularly of the current exempt classifications, there are a number of additional financial issues you may want to consider that may not be particularly evident. So let's say you have a series of positions that are appropriately classified as exempt right now under the various duties tests, but you really don't want to be raising the salaries to the $47 level. You figure, okay, I think we'd be better off going to a non-exempt status, or what some people refer to as an hourly status. Some of the things you may want to consider position by position is there travel time involved in these positions? I have a number of clients where travel time for their exempt folks is huge. They do their duties all over the country. So if you move people to non-exempt status, you're going to have to consider whether some of that travel time, some of it will be compensable, and that varies a bit from state to state, and then you've got the federal overlay. The other thing to think about is the sort of notion of comp time. You know, with a non-exempt person, there really isn't. You really can't have comp time. I mean, what you can do, as most folks know, is within a work week, if somebody is, you know, getting close to the 40-hour threshold, you can take the sort of comp time in the same week. In other words, they don't work any additional hours in that week so that you don't have to pay the overtime. Of course, California is different in all respects. You know, you've got the overtime after 8 hours in a day and 40 hours in a week, and they get you coming and going there. But if we're dealing with most states, you don't have to deal with that. The other thing which is huge is for somebody moving from exempt status to non-exempt status, first of all, they're going to be in the mindset, because they've been an exempt employee, that I do what I need to do to get the work done. You know, I'm checking my email as Krista was saying. I mean, and everybody at this table and probably everybody in this room does it. When we leave work, as much as we try to, we don't really leave work, or at least I don't. So I'll say, oh, I want to see if so-and-so sent me this yet, because maybe I have a few minutes this evening to look at it, et cetera. So you've got to understand that your exempt folks are going to still be in that mindset. The practical problem of that there are two. One is they may not be recording that time properly, which can come back to haunt you, and that comes back to haunt you, not them, in terms of an audit. But the other thing, that can be expensive. You know, if people are checking their emails before and after their normal work hours, that's paid time for the most part, or doing work from home or offsite, that's paid time. So it's something to factor in when you're considering the cost of moving folks to hourly. There's also the administrative burden, and I probably used the wrong word here. It's almost, particularly if you've got folks that have been in exempt status for a considerable period of time, you really have to change the mindset, because you've got to have accurate time records every day. And if you don't, that's going to come back to hurt the employer, not the employee. The employee maybe in the short term, but the employer in the long term. And you've got to manage, you may not probably want to manage from a cost perspective, the number of hours they work. How do you move somebody who's used to, and good employees want to get the work done? How do you manage that in an hourly position? The other thing is the sort of impact on employee relations, and this is going to vary industry to industry. One of my clients said, oh, our people are going to love moving from exempt status to non-exempt status because they get unlimited PTO. And I go, oh, that's right. But in other industries and other workforces, it's a psychological impact on the employees, and this is part of the communications issue. Exempt status means I'm important. My job is core to this company, and now I'm moving to punching a clock. Even though very few people actually punch a clock anymore, there's that perception. So getting to communications.
And I just want to loop back
Oh,
in on
sure.
the financial impact.
absolutely.
So when you're looking at these folks who are currently classified as exempt but don't meet that 47 odd hours, looking at, say they make 42,000, increase to 47 plus looks like a big increase in pay. But what you also have to look at is if they are non-exempt, what are they doing that might get them to overtime, and how much overtime is that going to be? Are they doing a lot of travel time that would be compensable? Are they doing off-hours work? If they kept on doing that because we would require them to do that, how many hours would they be working and how much overtime would they be entitled to? Does that get them even higher than that 47 plus? If it does, can we mitigate that by changing expectations and changing job duties? So this is sort of an example of how this audit needs to be very thoughtful. Not only what are they currently getting paid, but what are they doing and what would that look like if they were non-exempt?
So in terms of communication to the employees, we're talking about when you finished your internal audit, or if you haven't done an audit, a full audit, you've done a mini audit to decide what you need to do, at least in terms of compensation. What about communications? Well, communications, particularly in this wage and hour law area, I think is really key. It's key to your work environment, keeping a positive work environment, productive work environment, but also in terms of managing your legal risk. So some things to think about. Employees become disgruntled for many, many different reasons, of course. But sometimes I think that employees become disgruntled and start to make trouble for you in this area in particular because of the lack of communication, or the lack of the failure to communicate, to think about carefully what you're going to say, when you're going to say it, what you're going to say to whom, who's going to deliver the message, and who's going to answer the questions, So my caution is to be very deliberate in your communications, plan them, run them by legal counsel. I really would do that in this area. Because this may be one of the factors that ends you in, a wage and hour audit, or wage and hour litigation if you don't. If the changes are going to affect a large number of employees across your operation, consider whether you want to do an overall communication to the entire workforce about what's happening here and what's motivating it, so you can at least control, you can never control the conversation, but you can at least control the rollout of the conversation, and then have separate communications to the affected employees. In doing this, consider whether you want to combine this communication with a communication about updates to job descriptions. You can talk in terms of, we use the new regulations as an opportunity to evaluate how jobs have evolved. That helps people understand why the changes, so new job descriptions. Explain the reasons for the changes, and again, you want to script this with your legal counsel. Explain the economics of the changes to the individual. Explain to them so that they understand what's happening. So if they're moving from exempt to non-exempt status, and you're lowering the hourly rate, let's say you didn't calculate the regular hourly rate based on dividing their current weekly salary by 40, you lowered it. That's how they're going to view it. Explain to them, if it's true, how you've devised their compensation so that it will essentially be what they were making. Their hourly rate is now going to be X, but you regularly work. We've looked at, the workload in the group, and we understand that you regularly work, 5 to 10 hours of overtime a week. We're not guaranteeing you that you will have 5 to 10 hours of overtime, but we have set the compensation accordingly. Explain it to them. People can often accept change more readily if it's explained to them. And possibly the most important, ensure that they know who to go to when they have questions. So they've met with you, they've gotten their new compensation, their new job description, they thought they understood, but they get back to their desk and the grousing starts. It's human nature. It's about compensation. Compensation is key to everybody. Make sure that your message to them is who they can come and talk to within your organization, so they don't end up calling. Maybe they'll come and talk to you rather than calling their attorney. I am going to turn it over to Ashley, who is going to scare us to death, I think. But it's good for us, right?
Okay, so you guys have been given a lot of information today. Some of it has been pretty technical. A lot of it has been confusing, at least on some level. And so my job is to really highlight to you the importance of why employers really should take the time to understand these regulations and make sure that their classifications are correct. I'm not going to talk for too long because I want to make sure that we have enough time for questions, but I do think it is important to highlight the risks of getting this decision wrong. So, as you can see from the slide, the consequences of getting a classification decision wrong are pretty costly. Anne mentioned, there will be an uptick in internal and external complaints, and you could be subject to a Department of Labor audit. You can also be subject to litigation. And I don't know what I did. Oh, okay. So, as we all know, employees can and do sue employers for misclassification. And under the law, they are entitled to a number of damages if they are correct. So the most common example is an employee who's classified as exempt, is working a lot of hours, and thinks, hey, I don't think I'm actually exempt under the law. So they bring a lawsuit, seeking most likely to recover the overtime that they said that they should have been compensated for had they been correctly classified. And so these are the things that the employee would get if they were actually right. The first is back wages. And what I mean by that are the wages, so in this example, the overtime, that they should have been paid had they been non-exempt. And the statute of limitations under the law is 2 years, but can go back up to 3 years. Additionally, the Fair Labor Standards Act allows an employee to recover liquidated damages, and that's essentially double damages. So let's say that the employee prevails. A court finds that they should have been non-exempt, should have been paid overtime, but they weren't paid overtime. And so they were deprived of, let's say, $5,000 in back wages. A court can then say, okay, I am doubling that $5,000, awarding you an additional $5,000 as liquidated damages. And that's meant to compensate the employee for the lost time value of those wages. Additionally, an employer who gets the decision wrong will have to pay attorney's fees and costs of the litigation. Both defense costs, so if you're being sued, you have to pay your attorneys to defend the lawsuit and to litigate the case. And if the employee prevails, or even if it settles, the employer will end up paying the employee's attorney's fees and costs for bringing the suit. And so I've listed some examples of those costs, including court costs. Discovery can be very expensive, as well as other litigation costs. And even if the employer decides, hey, let's mediate that costs money too. You have to pay the mediator to prepare for mediation and engage in the mediation. So as you can see, all of this adds up to a very costly mistake if you get the misclassification, or if you get the classification decision incorrect. Now, it could be the case that one employee is suing you and saying, hey, you got it wrong for me. But more often than not, in classification cases, it's going to be brought as a class or a collective action. Now, I'll get into the differences between the two in a minute, but essentially it's a group action brought by one or maybe a handful of employees saying, you not only got this wrong for me, you got it wrong for a whole group of people, the whole group that the classification decision affected. And now you have to pay all of us back. And so it can be very costly, and it gets very complicated. So a collective action is the action under federal law. It's an opt-in, which means that while it's brought by one or a couple employees, the employees who are interested in the suit have to affirmatively join it to be a part of it. And it's covered, what most often happens is that the employee will ask the court to what's called conditionally certify this group of people, who everyone was affected, and ask the court for permission to then contact everyone, let them know about the suit, and give them the opportunity to join. This could involve posting this judicial notice in your workplace to let all affected employees know about this lawsuit. The second group action is a class action, and this is brought under state law. Both Ingrid and Ann mentioned state law, and that a lot of state laws have FLSA equivalents. And under state law class action, everyone is automatically included. Everyone who's affected is automatically included, and unless the court decides that class action treatment is not warranted, that they're not, that they don't meet the factors. More often than not, or happening more frequently now, plaintiffs are actually bringing both in one suit, bringing both a collective action under federal law and a class action under state law. So as you can imagine, these turn out to be very big, time-intensive, expensive cases that are difficult to defend against. Compound all of this with the standard that's applied in these cases, and you'll really start to worry. So under the FLSA, it's essentially a strict liability standard. And what this means is what really matters is whether you got it right or wrong. Doesn't matter if you tried but got it wrong. It doesn't matter that this law is really confusing and you got it wrong. Doesn't matter if you had the best of intentions. Doesn't even matter if you had some sort of agreement with the employee, or the employee really wanted to be exempt because they considered themselves professional. None of that matters if you don't meet the regulations for them to be exempt. The good news is that there is a good faith defense to some of the damages. And so if you can show that you did try and you weren't intentionally violating the law, the court will give you some credit. And essentially, I mentioned the Fair Labor Standards Act has a statute of limitations of 2 years, could go back to 3 years. So if you prove the good faith defense, then it's at 2 years. They don't get that additional third year, and there are no liquidated damages. So that essentially cuts the damages in half right there. So what can you do or what can you show this good faith defense? How can you prove this good faith defense? They'll look at things like, what did you do? What did you do to try and get it right? Did you contact your attorney to see if you were getting it right? Did you engage in those audits to make sure that your employees were actually falling within the correct classifications? All of that is going to be put at issue. But if you can show that, again, the damages will be mitigated substantially. So that is all I have on the scare tactic. The takeaway is...
We're shaking.
Right? Yeah, get it right.
Again, so the takeaway is be proactive. It's better to get it right on the front end. Do all of the things that Ann and Krista were giving you advice on. Contact your attorney, do the audits. Use this as an opportunity to look at your classifications and make sure that they're correct.
Okay. Well, thank you. Thank you, Ashley and all. Hopefully that gets you down the road quite a ways for knowing what these new regulations are all about. We're going to use our time that we still have together to answer some of your written questions as best we can. And we'll try to do these pretty quickly so we get through them. I'm going to take a couple here first. One of them, I just love this question. How does all this impact internships for entry-level or college students who may receive a stipend? Well, here's the deal on those internships that people want to say are non-paid internships, or maybe we'll just give you a little flat stipend. The federal DOL has an opinion letter that they issued long ago that tells there are 6 criteria that have to all be met for an intern to be unpaid. You have to meet all 6. And one of them is the intern really doesn't do much, doesn't help, kind of gets in the way of other people doing things, all right? The intern does not displace regular employees. When I say those 2 things, you guys are kind of laughing. It's like, oh yeah, we should be paying this intern, right? Because otherwise we don't have an intern. We want that person to do some things and helpful things and even kind of make up for what an employee didn't do. Okay, what does that mean? That means it's a paid internship. So unless that person is going to meet one of the exempt duties tests, that person's probably going to have to be paid non-exempt and keep track of hours, because most interns don't have enough independent discretion and judgment to be a professional or to be an administrative, and they're certainly not an executive. You don't bring an intern in and put them in charge of something. So most interns should be paid. Now, is that the way it works in real life? I would be the first to say, no, I hear about that all the time. But if the Department of Labor ever gets it, they won't like it. Okay, here's another question I'm going to take because it's kind of 2 I can combine. And people are asking, what is that 10% really? We pay bonuses for people that could meet the 10%, but we don't pay it until the second payroll after the close of the quarter. Sorry, too late. The regulations are very specific. Has to be paid the first pay period after the end of the quarter. So either you got to move up the payment or something else. Now, it says, does the 10%, must it be guaranteed? And the answer to that is yes. You'll see in that one handout with the blue on the cover, there's a little paragraph at the bottom of page 5 from the DOL directly that says, well, even if they don't earn that incentive that you thought they were going to earn at 10% to make up for, to get them to $913 per week, you got to pay it anyway. So when I think about that in practical terms, I'm not sure how helpful that 10% really is. But you may consider that. And then the other thing is, what about we have a person at $37,800 approximately. When we add her quarterly bonuses, she goes over $52,000. Does this mean we should adjust the base and the bonus and all of that? Well, remember what you have to do. If the quarterly bonuses get to an annual of 52, I think you're going to be in, you're okay. But remember, the bonuses can only equal 10% of, if you're paying weekly, then 10% of 931. That means 822. I did the math. If you pay biweekly, that means the person has to get no less than 1644. If you pay semi-monthly, it's 1781. If you pay monthly, it's 3561. So it's 10% of their otherwise guarantee per week, per monthly, et cetera. But you have to pay it on a quarterly basis and no later than the first pay period after the quarter ends. If you still have questions, I'm glad to help resolve those, but those are the rules. Ingrid.
Okay, I'm just going to do one quick one and then continue down the line. We are a shelter, people serving people. We do not sell goods and services. However, we raise funds in excess of $500,000 a year. Are we exempt from the DOL's exempt, non-exempt requirements? So you may well be an exempt entity. You may not be a covered employer because you don't have revenue from sale of products or services at the $500,000 level or above. But I wonder, are your employees engaged in interstate commerce, as we've discussed? And again, even working in a shelter, I think about the example of the box of Kleenex or bar of soap that is in the shelter, and did that come from across state lines? And it probably did. So I think this is a really tough issue for nonprofits, this whole interstate commerce application. But as Mary said earlier, I'd really proceed with caution if I was a nonprofit in concluding that you don't have to comply with these laws. I think the safer bet is to either do a really deep analysis with help of legal counsel or consider yourselves covered.
I have a couple here that I think I can answer real quickly. One is, what about on-call time? This company has a help desk person or persons that carries a cell phone during off-business hours and responds to emergency calls. I assume, even though the question isn't here, that do we have to pay them for the on-call time? This issue of on-call time has some fairly complicated definitions behind it, case law, et cetera. But in essence, what the DOL, what the courts look at when they're determining whether the full on-call time, if I have to be on call from whatever, midnight to 8 a.m. or whatever it is, whether the full on-call time has to be paid, it depends on how much freedom the individual has. So in this, can they go about their daily activities? Are they really free during this time period? That's a practical look at it. If you want more detail about this specific position, please reach out to one of us. But in the description, if all the person has to do is carry a pager, on certain times during the weekend, and they can still go to the movies. They can still, they don't have to be within any particular radius of the business. They're free to go about their daily, activities of their life. You will not have to pay for the full on-call time. You do, of course, have to pay for all working time. So for the minute they take the call till when they've completed the task, you pay for that, and that should be recorded. The second question is it's sort of the monumental question. What does it mean to exercise discretion and independent judgment as to matters of significance? I could write a book on this, but the specific question is, whether if an employee needs to run decisions by their supervisor, does this mean that they don't exercise independent judgment and discretion? This question honestly can't be answered without more detail. I mean, honestly, I would need to hear about, what is this position? Where is it within the hierarchy? What does this person do day to day? This specific question that the individual is asking is part of that, but it really can't be answered in isolation. If someone has to, from time to time run a decision by somebody else, that doesn't destroy exempt status, but it's definitely a factor.
Thanks. So I have a sort of related question. When would an executive assistant be considered exempt under the administrative duties test? For example, scheduling and managing calendars for high-level executives, project management, creating complex reports, and managing customer complaints. I don't think most of the exemptions are entirely black and white. The administrative employee exemption is the most gray of all of them because of that discretion and independent judgment with respect to matters of significant test. So that's that two-part exemption where they have to be engaged in office or non-manual work related to the general business operations. Executive assistants probably meet that test, but the key is, do they exercise discretion and independent judgment with respect to matters of significance? Most executive assistants probably do not, but some do. Yep, courts have found that some do, and it's going to depend almost entirely on the level of discretion and judgment and how significant those matters are.
All right, I have a question on what the best practices for lunch breaks are, dealing with lunch breaks. So assuming the person is not exempt, how do you deal with compensating or not compensating lunch breaks? And so my recommendation would be not to do an auto deduct policy. Rather, I think it's a better, safer course to have the employees punch out for lunch if you're not paying for lunch. And because that would be the safer course in that the employee then can't turn around and say, well, you automatically deducted it and it was on me to come back and say, no, I should have been paid for that. In the alternative, it allows the employee to control, when they're taking their lunch and to clock out accordingly.
Yeah, and I would second that advice. One of the audits my clients had was that very issue, and they did not require their employees to clock out for lunch and then clock back in when they came back. And so their time record ended up being evidence against the employer in the audit. Because as part of the audit, the employees said, oh, we didn't always get to take lunch. The company did an auto deduct of 30 minutes every day. And after the fact, the employee said, oh, no, we didn't get lunch. Most days we didn't get lunch. So we settled that matter, thankfully. But that's the reason to do an timeout, time in. Okay, I think we're right at 9:30. We are. So we're going to cut it off here. I have a question from somebody who actually signed their name. That's good. I'm going to try to find you quickly, and I'll answer your question. Maybe some of us others will do the very same. But we hope this has been informative and helpful for you. We thank you again for coming, and we wish you a very good day. Thanks.